Hello.
Hello, thanks for giving us some time. Well, I have a better understanding, having spoken with the two of you about where this is going. I'm not sure whether the two of you might not want to share some of the things you shared with me with each other. It seems to me that there are two fundamental issues that need to be resolved today. The first is, what are the two of you going to do about this Noki offer that's out there, whether or not your company will have the opportunity to respond or submit proposals on that. And then I think moving forward, it's going to be important for your two clients to have a better understanding about what sorts of products fall underneath this right of first refusal contract language, because it's clear that's what brought us here today, and your interpretation do not seem to get to the same answer. And so I think maybe we don't need to rewrite it, but we need to have a better understanding. You two need to have a better understanding of what it is that is covered under those terms. So I leave it to the two of you to decide what's more important to you today. Is it more important that you resolve the immediate issue of the Noki contract, or would you rather spend the time talking about, in the abstract, what is it that we really agreed to?
Well, I guess I would like to know from Sharon what Zig's view is in terms of a long-term relationship with Shenzhen.
Fair question. We are assuming that the full production goes as we anticipate with the tablet scanner. We expect that relationship to continue, and we don't see any particular reason why we would remove that business from Shenzhen and take it anywhere else. So
That's
again,
good news.
good. I'm glad you think that. We currently have a 1-year agreement, and so again, assuming that we stay on track with all of that, we would entertain continuing that agreement going forward.
Okay. And so if Zig sees, and by the way, I appreciate hearing this, and I know because I've talked with my principals that Shenzhen has the same view in terms of looking to Zig as a long-term working relationship. We see it as a partnership, and quite frankly, as fitting quite well in terms of our own long-term business plan, and we believe that we will continue to bring strength in this area. And frankly, we're confident that you would not find a better manufacturer for the technology that you develop. If we see promise in this relationship, separate from the language of the contract, my clients are a little bit unclear why you would not even entertain the opportunity for us to bid on further business.
Well, I think here is where, and I mentioned this when we were all together, and so let me say it a bit more explicitly. Zig's business model calls for us not to tie ourselves exclusively to one manufacturer. That, as a company, the policy that the company has always undertaken and philosophically believes that it would be just a bad decision for us to be so closely aligned that we rise and fall with another company. And as a result, we want to have a strong, good relationship with Shenzhen. We see that the future in terms of this tablet manufacturing, and we would like to be able to work with other companies in terms of other systems that we do. And it doesn't matter how fabulous Shenzhen is, we would still believe that.
Well, I appreciate that. And I guess it's important to say that that's something to have been negotiated at the front end of the exclusive manufacturer. That the nature of our business relationship was defined at the front end. It's unfortunate that we're needing to define or redefine it here at the table. And it's also unfortunate that neither of us were the agents at the time that the contract was drafted, so we don't have that individual history. But be it as it may, Well, two things. Number one, what you're saying makes perfect sense. It's very clear that as much as we value Zig, you're not our only client. We work with many companies, and it makes perfect sense that you, as a growing technology company, would also want to work with a variety of business partners. But again, that's something to be addressed at the drafting stage of a business agreement, not at the point where the four corners have already been defined. And so, as we see this contract, it's pretty clear and straightforward that, at least in terms of scanner technology, and specifically the kinds of things we're working on together, that this is not only what was intended under the contract, but this is in fact what the contract said. Now the reality is, we want to continue doing business with you. We are willing to be flexible as we address how to deal with the Noki situation. If there is a realistic prospect that we will have an ongoing business relationship. It sounds like that's true with respect to the current contract. I would like to hear some tangible assurances that that in fact is true in terms of other business areas, because frankly that's going to influence the strategy that we pursue moving forward.
I sounds a bit like a veiled threat to me.
Not,
However,
not at all. I'm being honest with you.
Okay. Yeah. First of all, I agree that this is something that should have been more clearly defined. I think what may have happened that our counterparts chose to live in the ambiguity and allowed to exist these two competing ways of interpretation. Because as I read the contract, I can read it so that it seems perfectly clear to me that we are not in breach. And so I think that we will have to agree to disagree about who the contract on the face of it.
Okay.
Because I actually don't think that it calls for us to have shared any of the fact that it's not a product, be that as it may. I think that we certainly can go forward in terms of the tablet scanner. I think that as technology evolves, the tablet scanner is eventually going to be passé, and there will be something else that comes on. And I think that Shenzhen, again, assuming that the production goes as we all anticipate it will go, and the relationship continues in the way that we anticipate that it will, and we've worked out all of these other things, that as things change, Shenzhen once again may be someone who we would like to bid a new piece of, a new product with. I can't say exactly, it doesn't foreclose it in anything unless we have a real major breakdown over this issue. So in that respect, yes, I think that we can be talking about some ongoing, continued ongoing relationship. So long as Shenzhen understands, just as you said, that we are not your exclusive company you work with, that you will not be the exclusive company we work with.
We were very clear about that. And frankly, coming full circle around, maybe this is to use the expression, the elephant in the corner. We have not been privy to the specifications that we're talking about in terms of Noki. And this may be a tempest in a teapot. Mm-hmm. Were we presented with those specifications, we might have looked at that and said, that's not our business. Mm-hmm. We don't do that.
Right.
But we have been prevented from even making that assessment. And so perhaps what would be helpful moving forward is for us to exchange that information so that we can see it and see whether, in fact, it continues to be a problem or is not a problem. We're confident that if it's not something we produce or a direction we choose to go, we're not going to try to compete for something that doesn't fit our own business model. And so there's no problem there. If it is something that fits within our business model, it would seem to be in your best interest to be able to evaluate competing bids for your business. And so I don't see a downside there. perhaps for purposes of this dispute only, and without waiving any other rights or any inference that we are rewriting the terms of the contract, that we would look at this as a one-off where there is not a right of first refusal by Shenzhen. That we would look at it, we would talk together, and we would determine whether this is a product. We would, if it's appropriate, we would make a bid, but we would not insist that we have right of first refusal as to this product. I also think it would be helpful as a preventive measure moving forward for us to engage in further conversation to more clearly define what this language means that's ambiguous. I don't think it's helpful to either company to try and define that language while we're in the middle of a dispute, because, as you've said, you have your interpretation, we have ours, and I don't know that we're going to find a meeting of the minds on that.
Right.
So I would propose a two-step process. Number one, you provide us with information on the Noki bid and give us an opportunity to look at it and to present under the terms of the contract. We have 30 days within which to present our own offer. We would not claim to enforce any right of first refusal with respect to this one piece. And then you would either accept or not accept whatever bid we propose if we present it. And then once this is laid to rest, we then agree to meet and reach agreement on the interpretation of that contract language.
I like the direction that we're moving on this. I think that makes a lot of sense for us to try to bifurcate this. And I am willing to entertain as a one-off in terms of not precedent setting, not pursuant to the contract, that we would share this bid with you and give Shenzhen an opportunity to put in a proposal. It would actually, therefore, if it is possible to agree to a different term rather than 30 days, do you think that Shenzhen would be able to produce a response within 15 days? So then it would be clear that this is not pursuant to the contract. This is two companies that are exchanging information.
It's hard for me to commit on behalf of my company that they can produce a bona fide bid in 15 days when we don't know what the specifications are for that bid, although we do work quite quickly. It sounds like what you would like to achieve is some signal that this is not pursuant to the contract. And if it were a 30-day period, that it would appear to be pursuant to the contract. What I would propose is that we make this review period 25 days. It's constructively the same amount of time it would give my client the time to do whatever research and work that they need to work it up, but it would also signal that it's not under the terms of the contract.
Right.
I'm not authorized, I've not been expressly authorized to reach that term, but I am confident that if I bring it back to my client, I can persuade them in very short order, maybe as simple as a phone call to that. But I think that meets your need of making it clear that the agreement we would reach at the table today is not an interpretation of the contract, but is in fact a settlement of a dispute.
And in fact, Lynn, I don't know if in the written terms of the agreement, if perhaps we could even have language to that effect, that that we will be sharing this bid and that it is in settlement of this dispute and not pursuant to any term of contract. Is that acceptable?
Yeah, as long as ZIG is in fact will make a good faith effort to review whatever bid we present in the event we choose to present one, then there's nothing more that my client would want, because frankly, we're a very competitive company, and when we choose to compete on a market, we're successful. So we will stand on the quality of what we present rather than leverage.
And let me also just make sure that we don't have any misunderstanding. ZIG is under no obligation to accept
With,
the terms.
with respect to
To
this
this
one disputed issue, yes, that's correct.
Right, so the bid will come in, it will be reviewed, but Zig is not under any obligation to accept this bid.
Yes, and I just want to make sure that we're clear. It's correct that Zig is not under any obligation. That would be tantamount to a right of first refusal.
Right,
And Zig is representing, or you are representing on behalf of Zig, that this is not a pro forma review, that this is in fact a good faith review of a business offer that we would be extending should we choose to do so.
yes, it will be a legitimate review, and again, I want to be upfront, and I don't want to be misleading in any way. There is a strong incentive for Zig to enter into this negotiation, into this agreement with Noki. And so it would be, is it impossible to break that? No, it's not impossible. I mean, sure, maybe there is a reason why Zig won't do it. But I will say that there is a strong likelihood, given Zig's business model and given what Zig is trying to accomplish, that the Noki bid will stay with Noki. So I don't want to mislead you.
No, I appreciate that. And what we are looking for is an above-board, good faith relationship going both ways. On behalf of my client, I am offering something in settlement that we believe we are not obligated to offer.
Mm-hmm.
In fact, we are offering what we would consider to be a compromise that is unnecessary. You perhaps have a different perspective.
I would view that what we are offering is equally that
And
type of
so
compromise.
what we're looking for is recognition that we're making this effort because we believe that there is potential in our future business relationship, and that we want it to be a constructive relationship and not one where we need to fight.
And I agree with that. I do agree with that wholeheartedly.
Okay.
And on behalf of Zig, I know that that's what they believe to be true.
So this is good news. What I'm hearing is that there are several agreements on the table today. First of all, you're agreeing to honor the contract with the tablet scanners and fulfill that one-year contract with regard to that particular manufacturing process.
And I'm hearing that there is a prospect that that will continue beyond the 1 year.
Correct. Then, in terms of the short term, for the purposes of this one Noki contract dispute, there will be an agreement drafted that says that your clients are able to produce an offer based on the specifications that they get when they review the Noki offer, and that Zig is under no obligation to pursue the offer, but they will evaluate it on a good faith basis, and you will do your best to provide a competitive bid.
Mm-hmm.
If
And
you're able to provide
if-
it. I mean,
Right,
Right,
if
right.
and
If
we
it's
may
even-
choose not to.
Correct, and that you have the option to decline to even present an offer.
Mhm.
And then at some future point, the two of you will sit down and draft a better version, a more clear version of what you think this contract should and arguably did say from the onset. Is that right?
Yes.
Okay. Is there anything else that we need to talk about before we wrap up here at the table today?
Well, I would be happy to offer to draft the agreement pursuant to this mediation and send it to you within the next 2 or 3 business days. I think it'll be pretty straightforward.
Mhm.
I do need to go back to my client and confirm the 25-day period. And that's not so much in terms of a legal issue, but really a technical issue, whether in fact the technical team would be able to prepare a bid in 25 days. I'm pretty confident they can. I can get that answer to you by the time I present you with a draft.
Okay,
But I'm confident that I can persuade them to.
that would be fine.
Okay.
And from your perspective, Sharon, anything else?
No, I think that addresses it.
Great.
Well, thank you for your hard work
Well,
today.
Thank you.
Thank you. Thank you very much.
Thank you. Thank you. Nice to meet you.